Good morning, Honourable Chair, Honourable members, members of my team, the parliamentary legal team, media, and other colleagues in the room. I can indeed confirm, Honourable Chair, that that is Ms. Shamila Batohi. We have consulted with her, and yeah, I confirm. I don't think anyone else would want to be an imposter in that position.
Okay, thank you so much. We are going to move to the next item, and welcome Honorable Sangoni. The next item, Advocate Batohi, with due respect, we are going to administer oath. And before we do that, allow me to read the following to you, that you have been invited to appear before this committee, the ad hoc committee, to investigate the allegations by Lieutenant General Nhlanhla Mkhwanasi, the Provincial Police Commissioner in the province of KwaZulu-Natal, for you to provide information in relation to the committee's oversight work. The committee has been tasked to investigate allegations made by the KwaZulu-Natal Provincial Commissioner, which include, among others, the alleged unlawful disbandment of the Political Killings Task Team, otherwise the PKTT or the NPKTT. Secondly, alleged moratorium on the filling of vacancies within the South African Police Services, the SAPS, and alleged corrupt relationship between senior leadership within SAPS and members of the public, as well as political interference in the work of the SAPS. In extending the invitation to you, the committee chairperson has indicated that you may provide such information to the committee if you so wish under oath in terms of the powers, privileges, and immunities of Parliament and Provincial Legislatures Act. Please be informed that by law you are required to answer fully and satisfactorily all the questions lawfully put to you, or to produce any document that you are required to produce in connection with the subject matter of inquiry, notwithstanding the fact that the answer or the document could incriminate you or expose you to criminal or civil proceedings or damages. Advocate Batohi, you are, however, protected in that the evidence given under oath or affirmation before a House or Committee of Parliament may not be used against you in any court or place outside Parliament except in criminal proceedings concerning a charge of perjury or a charge relating to the evidence or documents required in these proceedings. Please be aware that in terms of Section 17(2) of the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act, a person who willfully furnishes a House or Committee of Parliament with information or makes a statement before it which is false or misleading commits an offense and is liable to a fine or to imprisonment for a period not exceeding 2 years. You are required to take an oath to affirm that the evidence you are about to give is truthful. Which one do you elect, Advocate Batohi, oath or affirmation?
I will take the oath, Chair.
Thank you so much. If you will then say aye and state your names in full.
I, Shamila Batohi,
Swear that the evidence I shall give
swear that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
And so help me God.
So help me God.
Thank you so much. SC, we are going to run until 13 hours. Thank you so much.
Thank you, Honourable Chair, Honourable Committee members. Good morning, Ms. Batohi. How do you want to be addressed? Ms. Batohi, Advocate Batohi, NDPP,
I don't mind, whatever
or
works.
some other?
I'm okay with
Advocate
all of the above.
Batohi, let's keep it formal. You are the National Director of Public Prosecutions, having been appointed to that office on the 1st of February 2019 by the President in
That's
terms
correct.
of 179 of the Constitution and sections 5 and 10 of the NPA Act. And you are due to retire soon.
That's correct, at the end of January 2026.
So maybe just to kick off, just describe briefly your experiences in the office, the ups and downs. Don't need to dwell too long on it.
Sure. Didn't expect this question, but I'm happy to take it. It was, well, I took office on the 1st of February 2019. I came back to South Africa having spent just short of 10 years, 9 years and 3 months at the International Criminal Court in The Hague, working in the Office of the Prosecutor as the Senior Legal Advisor to the Prosecutor of the ICC. Prior to that, I had worked in the Prosecuting Authority. This is my 40th year as a prosecutor. I was a DPP in KwaZulu-Natal, worked in various, was part of the investigation task unit that President Mandela set up in 1995 to investigate hit squads in KwaZulu-Natal. And I think before the TRC, it was perhaps the most important post-apartheid unit that was put together to investigate atrocities that were committed during the apartheid era. There were 2 prosecutors there and a team of investigators. We reported to a board. And yeah, that was 96, 97. Worked there, was the DPP in KZN, headed up the Scorpions in KwaZulu-Natal for about 2 years when it was set up, and then became the DPP, went abroad and then started here in 2019 as the National Director. Came back to South Africa to take the call to serve the people of this country. And at a time when it was a difficult decision to make, given what the country had come through. But my commitment to serve brought me back home. And coming into the National Prosecuting Authority in 2019 was a difficult situation because you were trying to rebuild an entity which, like many other entities in South Africa, SARS, the DPCI, had been hollowed out in the decade or so before that. There were huge challenges in the NPA. Some of them I could just mention briefly. It's lack of capacities and capabilities, lack of, we had staff shortages, budgetary issues, skills and capacity, demotivated staff for various reasons. So there was a lot of work to be done. I came in without a leadership team, and it was about 18 months after I took office that my senior leadership was appointed in June of 2020, which was in the middle of COVID. We came out of COVID in 2021, and then that's when the rebuilding really started. And it's been, as you put it, ups and downs, a roller coaster, 5 years. But I don't know how much of detail you want me to go into, but what I can maybe say at this point is that the strategy was to turn around the NPA, to rebuild the NPA, so that it can really serve the people of this country in the way a prosecuting authority should. And so a lot of time was spent institution building, and that is the drudgery of institution building that doesn't make the headlines. The boring back office work, but is critical in any democracy to have strong institutions. And so there was a lot of time that we spent getting the capacities, capabilities, in order to do the work that we needed to, and that is to prosecute crime in this country. So we've done a lot of work, and I'm very pleased with how far the NPA has come in terms of institution building. And generally, the prosecuting authority is doing exceptionally well, but I can accept that there are areas where I had certainly hoped that at this time in my career, we would have gone further than where we are, particularly investigating and prosecuting state capture matters and some other forms of high-profile corruption. And there are various reasons for that. I shouldn't say for prosecuting them, perhaps to have, because many cases are in court, but getting through a court system to finality is something else, and I can talk more about that later if I'm asked. But that is perhaps the one maybe disappointment in terms of the things, how far we've come in the NPA. But apart from that, we've certainly built a strong NPA. There's a lot of work still to be done that the new national director will need to take on, but we've certainly set a very solid foundation to serve the people of this country in the way that a prosecuting authority should.
Thank you, Advocate Batohi. So perhaps we can start at the end in terms of your own statement. You accept that there's still urgent reforms that need to be effected within the NPA. Would you welcome the opportunity, this opportunity before the ad hoc committee to discuss some of them, given that you are now addressing the lawmakers?
Sure.
We know about the much publicized Zondo Commission, the Nugent Commission into governance in SARS. But this is the first opportunity, really, isn't it, to actually engage with lawmakers in terms of what still needs to be done, reforms that need to be effected. So perhaps discuss some of those which you deal with at the end of your statement from paragraphs 81 onwards.
Yes, thank you, Counsel. I think it's safe to say that, as I say in my affidavit, as South Africa, we are at a critical inflection point in terms of consolidating the rule of law and accountability in this country. And the allegations that have been made by General Mkhwanazi and where it has brought us, both the Madlanga Commission as well as this committee really gives us as South Africa the opportunities to consider what are the vulnerabilities in the systems. And these allegations have brought that into sharp focus in terms of the fact that there are vulnerabilities, and we have to accept that not just in South Africa, but throughout the world, institutions that are fighting for the rule of law are under serious threat and open to vulnerabilities, different types of vulnerabilities, open to compromise because of the type of the work that we do. And so this moment that we are at right now, should not be squandered. We really should use this as a catalyst for comprehensive institutional reforms that are critical to safeguard the integrity as well as the effectiveness of all the law enforcement entities across the system. As you mentioned, the National Prosecuting Authority has not been the subject of institutional review. The Zondo Commission looked at this issue for a long time. I'm aware that there was a lot of investigations that went into it. A number of, it was a time that I was not in South Africa at the time, but I'm aware that a number of prosecutors and other staff members of the NPA made statements, deposed to affidavits in the context of the Zondo Commission. But sadly, the Zondo Commission did not make any recommendations about systemic weaknesses within the criminal justice system, so that these could actually be acted upon to strengthen the system as a whole. And this is actually, It's actually, you know, the Zondo Commission did incredibly good work and looked through, you know, laid bare, you know, the extent of corruption in this country and the impact that this has had on the ordinary people of South Africa, where there's no water, sanitary, we all know this, basic infrastructure, schools, hospitals have all been impacted by corruption. And in the context of the Zondo Commission, they certainly looked at corruption and did incredibly good work, but at the end of the commission, they handed over to a criminal justice system that was seriously weakened during those years to do the work and hold people accountable. And into a system that was at that point, and still is trying to recover from that, to get to a point where we can properly deal with these matters. And so I think in that sense, I see this as an opportunity for the lawmakers to come together and carefully look at what are the weaknesses in the system and how do we actually, it's an unprecedented opportunity to look at what are the weaknesses, what are the recommendations that come out of this, and how do we at the end of the day strengthen the system to serve the people of this country and to deal with not just corruption, but the crime crisis that this country is facing, including organized crime and other forms of criminality, sexual and gender-based violence. So I see this as a really good opportunity for institutional reforms across the criminal justice system.
And is it dependent on whether or not the allegations, the wide-ranging allegations made by Lieutenant General Mkhwanazi on the 6th of July is or are verified or confirmed?
I certainly hope not, that it wouldn't be dependent on that. I'm hoping that the Commission and the lawmakers would take what comes out of this and then consider systemic inefficiencies and make recommendations in terms of how the system can be strengthened. One is to deal with crime, but also to address the serious vulnerabilities to potential corruption and compromise of whether it's police officers, prosecutors, members of the judiciary, etc. It's important that those kinds of recommendations come out of this.
Apologies for jumping around a bit in terms of the structure of your affidavit, but because we on the issue of institutional reform of the NPA, and we might as well just look at the paragraph 4.1.11 of the committee's terms of reference, which refers to the alleged existence of an organized crime syndicate controlled by drug cartels as well as business people, and its infiltration of key criminal justice role players involving politicians, law enforcement, SAPS, and the NPA is mentioned. And just fast forward, you had made, even ahead of the 6th of July Mkhwanazi media statement. Can you go to paragraphs 74 and 75, where you had made, there's a reference to a media interview on the 5th of June 2025 and the 6th of June 2025. Honourable Chair, those media statements or copies of it are now available in an exhibit. What's it, Talia, Delana? 11 or 12? 11. Exhibit 11, thank you. It's not attached to the statement. Advocate Batohi, you want to just address those and contextualize them?
Yes, thank you, Council. So, Honourable Chair, I was, at that point in time, during a media interview on the 5th of June, I made comments relating to infiltration of the NPA. And The next day, I then also had another media interview where I sought to clarify what I meant by that. But let me just explain to the House and Honourable Chair, honourable members, I speak to the House, I speak to the people of South Africa as well. And I want to explain that the reason that I made these comments at the time was that I had received confidential intelligence that there was a very concerted attempt to compromise members of the prosecuting authority. Also, concerted attempts to undermine and attack the National Director, and by individuals that are seeking to undermine the rule of law in this country. I'm not able to say who gave me this intelligence, but it was not passage talk, it was a formal meeting that I had with a particular agency, a member from a particular agency, and who gave me this information because the person thought it was important that as the head of the NPA, I should be aware of this attempts to undermine the work of the NPA. These were very serious. I was informed that the matter will be reported to the President, but I immediately informed the Minister of Justice about this and had a meeting with her when I briefed her on what I had been told. I also, at some time later after that, when the President was available, met with him and briefed him about my concerns about this. And my understanding is that there was not a, and this is my understanding, I'm not sure how these agencies work, but that there wasn't a particular tasking to look into the NPA. But I asked the President, I said to him, it's important that we understand what is going on and that there should be a tasking by our intelligence services to properly look into this matter. And that was the situation. Of course, when I made these comments, there were prosecutors in the NPA who also became concerned about this. And I hasten to add that, Chair, the majority of the prosecutors in the NPA are hardworking, committed prosecutors, and our performance will attest to this, that serve the rule of law and the people of this country and nobody else. But of course, the hardworking prosecutors were concerned about these comments that I'd made, and wondering about who do you trust in your work environment. And I said to them, we work in a work environment where we don't know who to trust. That is the reality. Even sometimes within the prosecuting authority, definitely within the SAPS and other partners, we work under conditions where you do not know who to trust. But you have to have safeguards, and we have to do the work to the best of our ability to serve the people of this country. I then I went to meet prosecutors across the country and started off in the bigger provinces of Gauteng, KwaZulu-Natal, Eastern Cape, and now I've traveled to Free State, Northern Cape, far-flung regions to meet with prosecutors, to assure them that the NPA, that as prosecutors, their commitment is to the Constitution and the rule of law. And that if there was any attempts to undermine any prosecutors, that it's not worth it, because your reputation is not worth being compromised at any point, that we serve nobody but the people of this country and the rule of law. And so I've been trying to make efforts to assure prosecutors that the work we do is important, our integrity is important, our personal reputations are important, and that we should never compromise that for anyone.
Two further aspects on that. At paragraph 73, you reference receiving information also from the National Commissioner and from the National Commissioner and Lieutenant General Khumalo about a potentially corrupt
That's correct.
prosecutor.
So, Honorable Chair, I received information from the National Commissioner and General Khumalo about a particular member of the prosecuting authority who was involved in organized criminality. I am not going to mention the name of that prosecutor in this House. The matter is under investigation. I immediately, upon receiving that information, I made a formal referral of the matter to the IDAC to investigate the matter. And that's the one direct evidence, bit of evidence or information, I should say, because I did ask the National Commissioner and General Khumalo. I met with them and I said to them, please, we need more evidence so that we can look into this matter, because it's unacceptable and untenable that any member of the prosecuting authority is involved with organized criminality. That there should be a fair process, and I've said this to prosecutors, there must be a fair process, and if you're found to be compromised, you will be kicked out of the NPA. We serve the people and we fight crime. We cannot be criminals ourselves.
But what's the status of this particular prosecutor, given these serious allegations coming from high-ranking SAPS?
I don't... The prosecutor is under suspension.
Okay. Okay. So it's currently not been temporarily removed from the system. Now, just while the second aspect I wanted to, just while we're at it, is you otherwise reference at paragraphs 71 and 72 some statistics with us relating to complaints or allegations of corruption, presumably less serious, but nevertheless complaints of misconduct at paragraph 71 and 72. Do you want to just briefly refer to that?
So,
in terms of...
Just a moment, Honorable Skhosana.
Thank you, Chair. I just wanted to make a seeking clarity question, because the Advocate Batohi is saying he can't reveal the name here. But if it's the same person who was mentioned in the media, why not revealing it here? Because in the media, if as members here of the committee, and the South African, some people knows exactly what we are talking about, who's that person we are talking about, why are we hiding it here? Thank you, Chair.
Advocate.
Chair, I will not want to hide anything from this committee. I regard it as a very important committee. But I do want to be responsible at the same time. I'm not sure who the person is that the honourable member is referring to. But even if the name is given to me now, I'm not going to make a comment about whether it is or isn't. It's not fair on the process. It's not fair on the person concerned. And this might turn out not to be true. We may not be able to verify this information. And then it destroys people's reputations and lives. And I think it will be hugely irresponsible for me at this stage, with just the bit of information that I have referred, to mention names in this House. So I would please ask the House to be understanding and not to insist that because I will not reveal the name, Chair, with all due respect.
Chair, the advocate says that he won't reveal the name, and he's not sure whether I'm talking about the same person. Do you know the name?
Chair, if I may ask The name of which person? The person in the media or the person in respect of whom the information was received?
No, the person you mentioned that is sitting at home, the prosecutor, which you said is sitting at home as we speak here.
I do.
But we are talking, you said you don't know that person.
No. It is not what she said.
Yes?
You alluded to knowing a person
The media is?
who might be on suspension because the report is in the media.
Yes.
And what we may have to check with her is whether the report that you have seen in the media and the report that she gives here are one and the same report, or are two different reports.
Yes. Yes, no, I agree, Chair. And maybe if he said that, if he can say it, is it the same person, maybe he doesn't want to mention, but if it's mentioned in the media and it's the same person and he says it's a secret, for me that's a double standard. I mean, we deserve to know as well, formally so, not from the media, but if it's a different person, it's okay.
Yeah. She says for the purpose of professionalism. Honorable Malem.
No, thanks, Chair. I thought she was suggesting we must just go home if she's going to proceed like that. Because we deal with names here. What are we dealing with? What are we dealing with here? We want to know who captured the criminal justice system. And if we can't be told names and we accept that, let's go home. Especially names that are out there. There is a prosecutor, I'm just forgetting the name of, is it Johannesburg or something, Pretoria, who's suspended by the president? 𝐬𝐮𝐽𝐝. What's difficult saying something like that? What's difficult saying something like that? If we're referring to 𝐬𝐽𝐝, or if there is more, we need to know. There is nothing unprofessional about that, because if we're going to proceed like that, we're becoming toothless. We cannot allow a situation where there is an allegation of a prosecutor who is being captured or infiltrated, and we are told we can't be given a name. If it was wrongly mentioned, there are recourse in South Africa where that name will be cleared. There are so many names of people being said here, people who are also in jail, people who are already on criminal trials. We get deep into those issues because we're seeking to unearth the truth. If it is true, indeed, there are people who are captured in the prosecuting authority. We want to know that. What if 𝐾𝐨𝐽 is wrongly accused? What if he's correctly accused? We need to come to a determination that, look, there is nothing in the NPA that suggests there is any infiltration by the drug cartel or anything of that sort. Or there is, and if we say there is, these are the issues. And these are the individuals responsible for those kind of activities in the NPA. So I don't think Honorable Skhosana is being irresponsible in that regard. Thanks.
Advocate.
Thank you, Chair. I really want to emphasize, honorable members, that I do not seek to be disrespectful to this committee. I haven't even said, the members have mentioned names. I haven't even said whether it is or isn't that name that has been mentioned. And I don't want to make it difficult for this House to be able to do its work. But given that I was given, I think at the level of intelligence, because I haven't even said it's evidence, I went back to the National Commissioner as well as General Khumalo and I said, can you please give me evidence of this? Because I need more evidence. And so I really urge that it will be hugely irresponsible of me to mention a name in this House on the basis of intelligence that I've received that may or may not be true. So I really urge honorable members to understand that I do want to help this House, but I do not want to put people's names at risk. For various reasons, you never know how people are put at risk. I mean, and we don't know whether it was a direct consequence of what happened in this House, but you know that our chief investigator of the IDAC was attacked a day or two after his name was mentioned in this House. But one might say, look, he is the chief investigator, it's not difficult, that you shouldn't really draw that conclusion. I will understand that as well. But it does put people at risk, and I do not want to be irresponsible and do that when all I've received is intelligence about the possibility that someone, well, about the fact that somebody is involved with organized criminal networks. Thank you, Chair.
Honorable Ngola.
Thank you very much, Chair. Chair, we have evidence before us that there are rogue sections within the NPA, which suggests that we must dig deeper to look into the allegation. And part of what has been a modus operandi of this ad hoc, Chair, was that names must be given to the committee so that it is actually assisted in formulating a finding and recommendations. From the evidence of General Mkhwanazi, whom part of it is what he termed as an intelligence information. So we have been able, for example, Chair, General Mkhwanazi stood in front of this ad hoc committee and said, him and General Khumalo went to the Minister of Police to brief him that General 𝐟𝐨𝐫𝐿 is a rogue element within SAPS in terms of intelligence information. So I'm trying to display, Chair, that this is not the first time we're dealing with the situation of this matter. And I'm trying to make the NDPP comfortable to mention the name of the person that she's referring to. It is not certainly a finding or a guilty decision if you mention the name. Part of what we've been placed on here, Chair, is that there is an evidence General Mkhwanazi even brought to the committee and later withdrew some parts of that evidence, and it was acceptable. So I want Chair, the NDPP to feel comfortable to provide the necessary finer detail of the evidence he's giving before the committee. Thank you very much.
Advocate Honorable Matthews. Sorry.
Thank you, Chair. Just to add on, number one, within our terms of reference, as a committee, I know this is an open, it's an open hearing at the moment, but we do have an option of a closed session. I'm not saying that we need to go there. We cannot have, we are wasting our time if we are not getting names. We're also going to leave, and when we go through our deliberations, we are going to say our National Director of Public Prosecutor gave testimony, but we have no proof. Because this thing of having classified intelligence reports is something that is so old that we've heard. I mean, if we go back, even in the history of Parliament, so many decisions have been made on intelligence or classified intelligence reports that we've never seen, we don't know. So we need to make a decision on if this thing is like that high profile, do we take it into a closed session? But I don't think it is that serious, Advocate. On a very serious note, there are many people that have come, they've been cleared and they've cleared their names, but we are definitely wasting our time if we are going to be protecting individuals who, number one, have already, you've said they've been suspended. That means there has been action that has been taken, and I don't think our citizenry is that stupid or not to be able to put it in context that this is still under investigation and they currently being suspended. We're also undermining the intelligence both of this committee and South Africans at large. Thank you.
Honorable James.
Thank you, Chair. Advocate, you've just mentioned that you don't trust crime intelligence. Am I right? Earlier on, you've said that you don't trust crime intelligence and now we are expected as South Africans and as this committee to trust crime intelligence. The purpose of this ad hoc committee is basically for show and tell. We want those names, and I don't think we're going to be okay today with leaving here, because everyone else's names, and I don't want to repeat what my colleague has just said. We've mentioned names of all other people that's implicated in this, and the words that were used was allegedly involved. I'm not sure why we can't do the same here today.
Advocate Batohi.
Thank you, Chair. Firstly, I want to make a correction. I didn't say I don't trust crime intelligence. I said there were people across the system that we couldn't trust. We don't know who to trust. Actually, not specific people that we don't trust. The way I said it is, I said you don't know who to trust. So, just to clarify that. Chair, I hear what the committee members are saying. It has always been the position that when we are investigating, we do not give names of anyone that is the subject of an investigation. From the NPA, we only mention the name of a person in any media report or publicly after the person has appeared in court. That is the only time we mention. We do not even mention that people are the subjects of investigation. Names are never mentioned by the NPA generally. That is our policy, and that is to protect people. I don't want to protect criminals, of course, but we live in a constitutional democracy, and we must protect the rights of people, even if you are the subject of an investigation. And I hear what the honourable members are saying about the fact that other names have been mentioned by other people that have appeared before the committee. I don't know whether that's right or wrong, but I know the committee wants to do its work and wants to get to the bottom of this. Maybe the idea of a closed session is not such a bad one, because it is at the level of intelligence, and I think it will be hugely irresponsible of me to mention the name of a person. It's easier said than done. We can sit here and say, there have been allegations and people have been cleared, but these things destroy people's lives. And as prosecutors, we have a lot of power to make these decisions that affect people's lives in a very real way. And I've always implored upon prosecutors to please take your responsibility seriously. The impact of our decisions impact people's lives. So we must make the right decisions and make sure we have the evidence when we make a decision to prosecute. But that is taking it to another level. At this level where we are here, when we make a decision to prosecute, we have a lot of evidence already. Here I'm in a situation where all I have is the flimsiest bit of intelligence with a name that may or may not be true. And I still urge and I ask the committee to respect that. I cannot say it in an open platform where the many people of South Africa are listening, and I want the people of South Africa to understand that I don't mean to be disrespectful to you at all. And this committee. I really want to be responsible and not destroy even a single life. It's one too many. So I unfortunately cannot say it in this open platform, Chair.
I want you to help us here. Because you give us a report here that the official is on suspension. Is that correct?
That's correct, Chair.
And then this suspension, who effected the suspension?
Chair, if I give details about this, it could reveal the identity of a person, and it becomes if you say enough about something that actually reveals the identity, it's the same as saying a name. So I really want to urge that I can say things in a closed session, as I said. I'm happy to consider that.
I hear what you are saying, Advocate. If you start investigations, because you want to discover certain things, you can say now, because we are still at a stage where we are investigating, we may not want to jeopardize the process. But if you investigate and reach a stage where you make a decision to say, Lakhanyan, we now come to a point where we suspend you, you are acting in public office, isn't it?
Chair, for the sake of clarity, I didn't say the person was suspended for this issue.
But the person is on suspension. Yes, that is exactly what I'm saying, that if you act in public office, any decision that is taken by, it's an administrative act, isn't it? And for sure you should be able to explain that decision, unless you were to say to us, like, you know, when we administered oath here, the law says you are expected to answer any question fully and satisfactorily, and failure to do so, you may be committing an offense. And if there was a law that prevents you to do that, maybe it will be advisable to you to say, I'm mindful of the oath that I've taken, but there is this law that prevents me. Because when you act in public office, the other arm of that action is accountability. You should be able to account on the decisions that you have taken, especially that, I mean, the suspension of a person or removal of a person from office is in public interest. I mean, the public wants to know why this person is no longer in office. How has it happened? Is this decision arbitrary or is it justified? If you understand what I'm saying, it's not like you are still investigating. A decision has already been taken to suspend the person. So what is it that makes it difficult to you, advocate, to say the person who is suspended is Soviet Lakhanyan?
Chair, I said that the person is not suspended for these allegations. And if I mentioned anything more about it, it may become clear who the person is. And for that reason, I do not want to say anything more about it. Chair, I would think that the Constitution actually requires me to act fairly when we take decisions. And this, in my view, is being fair to someone who may or may not be implicated in organized criminality. But of course, the matter is under investigation. Those allegations have been referred and they are being investigated.
Can I check honorable members who want to speak on this matter? Honorable Skosana, Honorable Ngola, Honorable Nomvalo, Honorable Malema.
Thank you, Chair. I'm sorry, SC. Perhaps...
Honorable Sols will be the last.
Oh. I'm sorry, to have... because there was a nice questioning to advocate. I never thought this matter is so complicated. But in my view, names have been mentioned. The president has suspended someone, which perhaps, maybe there's another ones who are suspended, some prosecutors, fine. But I don't think it's right, advocate. Because where to draw the line? When things are genuine or are not genuine, where do we draw the line? Because this committee sits here to probe these issues. The allegations which were made by General Mkhwanazi. Hence we are here. We are not casting aspersion to anyone. But we want the truth. But if it's an animal farm, names were mentioned here. No one ever complains about names being mentioned here. It's for the first time for me, from hearing from you as a national director of public prosecution. When you talk about people's life being destroyed, I can tell you, don't go there. Because he invokes pains to many South Africans who have lost their lives, others their livelihood because of the NPA. Some are still being prosecuted, for many years. Their cases are still in court. But we are going to come to those questions to you at a later stage. But for now, it was only about the name. Because the media has made those names. But we don't want to rely on the media because we are here. We don't want to have the merits of the case.
I don't want you
Thank you, Chair.
to debate the question. I want to hear you. What are you saying on this matter?
I'm sticking to my question, my earlier question. Thank you, Chair.
That the name must be revealed.
Thank you.
Thank you very much, Chair. It does look like the NDPP is putting a barometer or a barrier in that they can only disclose the name of the person once that person appears before court, which I presume that she means the first appearance. Chair, given the fact that we have agreed to seek for an extension as the ad hoc committee, I think for progress' sake, let's say we will require the NDPP or anyone who will be at the helm of NPA before we consolidate the report to submit a written report in specifically on that particular aspect. So that we proceed for now, but the committee must not be disadvantaged in collating necessary evidence so that that particular evidence informs what the committee finds in its findings and recommendations. So I propose, Chair, that before the committee does its winding up report, that evidence must have been sent through a written report to the committee. Thank you very much.
No, thank you very much, Chair. No, Chair, we just want to make a clear statement that if the NDPP continues to refuse to reveal a name, it means she is not cooperating to an investigation. Because here we're not doing oversight. This is not a justice committee being chaired by Honorable Ngola, where you give annual reports. We're doing an investigation, and names have been tabled before this committee. Names of people who have not even been charged. Just names of people who do not appear before any disciplinary committee. So it means you don't have confidence in this committee. Two, you are undermining our intelligence. What adverse impact is it going to have if you tell us that a person is so and so? There will be no adverse impact other than an impact that is imaginary. We are just imagining that there will be an adverse impact if you mention names. How? So we are going to understand you to be refusing to cooperate with this committee if you refuse to give us names. Yeah, we are investigating, so you can't tell us how we should investigate. We can't be told by you. We have terms of reference. We know what we are doing here. So don't undermine our intelligence. Chair, I'm in support of what Honorable Skhosana is saying, that the name must be revealed to help our investigation, to pursue our investigation, because that name might be relevant for us to take a certain posture with regards to this investigation. So you are refusing to give more insight about issues which are affecting our justice system if you refuse to give us a name. And we are not just asking from an ordinary person. You are the NDPP with a statutory responsibility to oversee the running of the NPA. And you come here and refuse to give us names as if it's a choice. It's not a choice. We're investigating you. We're investigating the allegations, I mean. And if we say give us names, unless you are telling us that you are refusing, then we're going to note it as such. We're going to write it down that you are not cooperating with this investigation. Thank you.
Honorable Malemo.
Chair, NDPP must know that she's got a duty to protect this country more than individuals. You can't say, I want to protect individual because of their rights and all of that. A rotten NPA, it's very dangerous to our constitutional democracy she speaks about. A rotten NPA is dangerous to the Constitution of the Republic of South Africa. So you cannot protect an individual over the Constitution of the Republic of South Africa. Just her failure to respond to this question, she must take a bag and go. She's not going to be useful to us. We are asking names. That's why we are here. We are told there are people who kept people is names. Who are those people? We want names of drug cartels. We want names of corrupt police. We want names of corrupt judges. We want names of corrupt prosecutors. That is the whole idea of us being here. So you call a witness, when she left home, she left saying she's going to do what here? She's coming to read a policy statement in an inquiry. Yeah, we even discuss boardroom. We're discussing pillow talk. Yeah. Yeah. That's how far we go. Now we're being told no, just a name. We can't be given a name of a prosecutor who's suspended. I know that there is a prosecutor called 𝐬𝐮𝐞𝐿 in Gauteng who's put on a special leave or suspended by the President of the Republic of South Africa. It is the President who communicated that publicly. What is so difficult for an NDPP to refer to such a case and say, for instance, we've got this case that is on, but I can't give details. This is what it involves. A lot of people came here and said so. This is a public information. But to come and say, I won't give you names, even on matters that are public, that is having taken a conscious decision that I'm not going to cooperate with them and I'm going to show them that they can't do anything. She's completely undermining us. To put it mildly, she's undermining us, and she left her home having taken a decision to come and undermine us here. What is so secret about telling us about a public prosecutor of a public prosecution? Everything is public there, except when you are dealing with the case. It says, I will give you a name when a person appears in court. The person that we're speaking about, for instance, 𝐾𝐨𝐽, he's not going to go to court. It's an inquiry that is on. The president is investigating a particular conduct, wrongly or rightfully, I don't know. So it means we'll never hear that name 𝐾𝐨𝐽 in this committee because he will never have a first day appearance in a criminal court. What happens? There is an internal, inquiry that the president has constituted. The head of NPA must know about that, must be comfortable to speak about it. And the refusal to speak about such an incident is to say, I'm not going to cooperate with you. Actually, the allegations goes further, which we are going to probe later when it is our turn to ask questions. They say, after they arrested advocate 𝐾𝐨𝐽, they are able to register cases easily. That's what SAPS says. And cases are moving smoothly in Gauteng. Is that true? We want to get into those issues, but if the head of NPA is going to shy away from that, then which issue are we going to deal with? We need prosecutors who are cooperating with drug cartels.
Thank you, Honorable Malema. Honorable Sauls.
Chair, indeed, advocate is required to give us names. It is true. However, it is not true that names has been given in this committee. We still don't know the names of 3 out of the big 5. Why? Because the witness stated that it is under investigation and the names will be revealed, and it can be revealed in camera. can be revealed in a closed session. So we must be honest about this, that it is true that advocate must give us the names. But the question is not must you give us the names or not. You must give us the names or name. But the question is how? Which platform? What is the requirement for you to give it in closed session? If we go by what has happened in the past in this committee, the statement was, I cannot reveal in public the names of the other 3 of the big 5, even though the committee wants to know, and that's what we are investigating. It's because it's still under investigation. You testified, advocate, that the person you are referring to is suspended, but the suspension is not connected to the allegations that you are referring to. In other words, whatever you are referring to is still under investigation. And it is for that reason that you don't want to publicly reveal the name, if I understand you correctly. This then satisfies the same requirements that was put forward before. Where I will disagree with you, advocate, is if we say to you, you must reveal the name, but you must reveal it to us in closed session because it is still under investigation, and you refuse at that point, then I will disagree with you. Because that would be you intentionally hampering us from doing our work. But if you are willing to reveal the name in closed session, that would be in line with our terms of reference. So, Chair, I support the position that the advocate must reveal the name. But if the advocate opts to do so in closed session, that is in line with our terms of reference, and she should be allowed to do that. Thank you, Chair.
Advocate Breitenbach.
Thank you, Chair. Chair, I understand the need for the members to hear the names, and we all need to hear them. Advocate Batohi has made it quite clear that the person she is referring to has not necessarily been suspended for the facts that we are now talking about. And she doesn't have control over the investigation, and the other agencies that are obviously involved in such an investigation. And so for her to sit here and publicly name people could not only undermine the investigation, but it could also undermine other agencies who are busy with important work. And so I would agree that she must be fully open and honest with this committee, but not in an open forum. And for the sake of progress, I think we should move on with everything else and then deal with this issue at the end, and in a closed forum. Thank you, Chair.
Honorable Sangwan.
Yeah, thank you, Chair. No, I think I've generally been covered by all the members who spoke, and I align myself with the recommendation on the closed session. Chair, because we were discussing this matter and we don't need an answer now, I can wait until we're questioning. But I'm hoping that Advocate Batohi is also going to give us the reasons why she recommended to the President that Advocate 𝐾𝐨𝐬𝐵 be suspended. I would appreciate that we get that. Thank you, Chair.
Pangazit.
Thank you, Honorable Chairperson. One, I actually wanted also to align myself with the shall I call the demand by this committee for the name to be actually mentioned. However, I do want to support Honorable 𝐬𝐮𝐬𝐽 in the proposal that he made, namely that perhaps at the end of this process, the NPA, whether it would still be Advocate Batohi or the new one, be able to actually supply us with the information related to the matter that we are dealing with right now, including the name. But I also am not comfortable if the advocate simply refuses to give the name, because
I want to protect individual because of their rights and all of that. A rotten NPA, it's very dangerous to our constitutional democracy she speaks about. A rotten NPA is dangerous to the Constitution of the Republic of South Africa. So you cannot protect an individual over the Constitution of the Republic of South Africa. Just her failure to respond to this question, she must take a bag and go. She's not going to be useful to us. We are asking names. That's why we are here. We are told there are people who kept people is names. Who are those people? We want names of drug cartels. We want names of corrupt police. We want names of corrupt judges. We want names of corrupt prosecutors. That is the whole idea of us being here. So you call a witness, when she left home, she left saying she's going to do what here? She's coming to read a policy statement in an inquiry. Yeah, we even discuss boardroom. We're discussing pillow talk. Yeah. Yeah. That's how far we go. Now we're being told no, just a name. We can't be given a name of a prosecutor who's suspended. I know that there is a prosecutor called 𝐃𝐨𝐬𝐿 in Gauteng who's put on a special leave or suspended by the President of the Republic of South Africa. It is the President who communicated that publicly. What is so difficult for an NDPP to refer to such a case and say, for instance, we've got this case that is on, but I can't give details. This is what it involves. A lot of people came here and said so. This is a public information. But to come and say, I won't give you names, even on matters that are public, that is having taken a conscious decision that I'm not going to cooperate with them and I'm going to show them that they can't do anything. She's completely undermining us. To put it mildly, she's undermining us, and she left her home having taken a decision to come and undermine us here. What is so secret about telling us about a public prosecutor of a public prosecution? Everything is public there, except when you are dealing with the case. It says I will give you a name when a person appears in court. The person that we're speaking about, for instance, 𝐾𝐨𝐬𝐿, he's not going to go to court. It's an inquiry that is on. The president is investigating a particular conduct, wrongly or rightfully, I don't know. So it means we'll never hear that name 𝐾𝐨𝐬𝐿 in this committee because he will never have a first day appearance in a criminal court. What happens? There is an internal, inquiry that the president has constituted. The head of NPA must know about that, must be comfortable to speak about it. And the refusal to speak about such an incident is to say, I'm not going to cooperate with you. Actually, the allegations goes further, which we are going to probe later when it is our turn to ask questions. They say after they arrested advocate 𝐾𝐨𝐬𝐿, they are able to register cases easily. That's what SAPS says. And cases are moving smoothly in Gauteng. Is that true? We want to get into those issues, but if the head of NPA is going to shy away from that, then which issue are we going to deal with? We need prosecutors who are cooperating with drug cartels.
Thank you, Honorable Malema. Honorable Sauls.
Chair, indeed, advocate is required to give us names. It is true. However, it is not true that names has been given in this committee. We still don't know the names of 3 out of the big 5. Why? Because the witness stated that it is under investigation and the names will be revealed, and it can be revealed in camera can be revealed in a closed session. So we must be honest about this, that it is true that advocate must give us the names. But the question is not must you give us the names or not. You must give us the names or name. But the question is how? Which platform? What is the requirement for you to give it in closed session? If we go by what has happened in the past in this committee, the statement was, I cannot reveal in public the names of the other 3 of the big 5, even though the committee wants to know, and that's what we are investigating. It's because it's still under investigation. You testified, advocate, that the person you are referring to is suspended, but the suspension is not connected to the allegations that you are referring to. In other words, whatever you are referring to is still under investigation. And it is for that reason that you don't want to publicly reveal the name, if I understand you correctly. This then satisfies the same requirements that was put forward before. Where I will disagree with you, advocate, is if we say to you, you must reveal the name, but you must reveal it to us in closed session because it is still under investigation, and you refuse at that point, then I will disagree with you. Because that would be you intentionally hampering us from doing our work. But if you are willing to reveal the name in closed session, that would be in line with our terms of reference. So, Chair, I support the position that the advocate must reveal the name. But if the advocate opts to do so in closed session, that is in line with our terms of reference, and she should be allowed to do that. Thank you, Chair.
Advocate Breitenbach.
Thank you, Chair. Chair, I understand the need for the members to hear the names, and we all need to hear them. Advocate Batohi has made it quite clear that the person she is referring to has not necessarily been suspended for the facts that we are now talking about. And she doesn't have control over the investigation, and the other agencies that are obviously involved in such an investigation. And so for her to sit here and publicly name people could not only undermine the investigation, but it could also undermine other agencies who are busy with important work. And so I would agree that she must be fully open and honest with this committee, but not in an open forum. And for the sake of progress, I think we should move on with everything else and then deal with this issue at the end, and in a closed forum. Thank you, Chair.
Honorable Sangwan.
Yeah, thank you, Chair. No, I think I've generally been covered by all the members who spoke, and I align myself with the recommendation on the closed session. Chair, because we were discussing this matter and we don't need an answer now, I can wait until we're questioning. But I'm hoping that Advocate Batohi is also going to give us the reasons why she recommended to the President that Advocate 𝐬𝐮𝐞𝐭 be suspended. I would appreciate that we get that. Thank you, Chair.
Pangazit.
Thank you, Honorable Chairperson. One, I actually wanted also to align myself with the shall I call the demand by this committee for the name to be actually mentioned. However, I do want to support Honorable 𝐬𝐮𝐬𝐽 in the proposal that he made, namely that perhaps at the end of this process, the NPA, whether it would still be Advocate Batohi or the new one, be able to actually supply us with the information related to the matter that we are dealing with right now, including the name. But I also am not comfortable if the advocate simply refuses to give the name, because names have actually been mentioned here. And 𝐼𝐻𝐻𝐾𝐿 did not actually beat about the bush in saying categorically that within the NPA, there are elements that have actually compromised the operations of the criminal justice system. So we cannot be overprotective of individuals, because we might be protecting the very element that we need to know about and deal with. Thank you.
SC.
Thank you, Chair. I was going to propose just a short adjournment for Advocate Batohi to confirm with Council to consider making the disclosure in camera. Thank you.
No, I will grant you that time during the break, because I think we should go ahead with the work of the committee. Advocate, I think you hear the sentiment of the committee, that the committee, one of its terms of reference, which we read to you this morning, is that it is also investigating alleged corrupt relationship between officials in public institutions in the criminal justice system and members of the public. And if we are going to successfully do that work and report to Parliament, but also when I carefully listened to you when you made your opening statement, you say this ad hoc committee and the commission, the work that they do provide an opportunity for Parliament to make necessary interventions in the strengthening of the law that we have. So it's going to be very important that we have. Remember, the reason why we want the names is we have to decide on the witnesses that we invite before us here. And if we don't have those names, all these witnesses, the reason why the committee said the first witness must be General Mkhwanazi was because we couldn't just sit like this and throw the bones on the floor and the bones will say there is an elephant here, there is a lion here, there is a porcupine here, you must call them before. General Mkhwanazi came here and named institutions and mentioned names of officials, and we were able to make decisions on who we must invite, who must be a key witness, who is secondary witness, and the order in which those witnesses must appear before the committee. So I will take solace to what the SC says, that during the break, I mean, when you come back from the break, you will give an answer as to how that name is going to be made available to the committee. And in this regard, I would like us to continue with the proceedings. Is that fine with you, Advocate?
Chair, it's a good first step. I will certainly confer with Council during the break. Whether we'll be able to come back immediately or whether I need to get a proper legal opinion on this is something we will consider. But I really want to assure this House I do want to cooperate with this House. And I certainly do not want to be disrespectful. This is important work, as you put out. So we will certainly look at how we can best deal with this issue. Thank you, Chair.
Thank you, Advocate Batohi. Can we perhaps just explore this very issue a bit further? What is the difference between the suspension of Advocate 𝐃𝐨𝐧'𝐭 by the President? Is it because he's a DPP and this particular prosecutor is not?
Advocate 𝐃𝐨𝐽𝐾 has been suspended by the President because he is a DPP. That is correct.
So the suspension in this case would it have been effected by you? As the
Well, it
the
depends.
NDPP
As
or-
I said earlier, Council, I don't want to say anything further because it could reveal the identity of the person.
Yeah, I'm just trying to explore what the reasons might be. I can understand from a reputational point of view that someone's name was still being accused, not be disclosed. But it is so that many names have been mentioned during the course of these hearings, and members understand it's on the basis that there are allegations. But there may be a different perception out there in the public that I can also understand. The other thing is this, you actually mentioned that the reason for the suspension is not related to what was mentioned to you by, I don't know, just you can correct me if I'm wrong, by Lieutenant General 𝐬𝐮𝐬𝐫𝐢 and the National Commissioner. It is for some other reason.
That's correct.
Isn't that a reason why perhaps the name should be mentioned? Because I think the concern is that given that allegations have been made by, amongst others, Lieutenant General 𝐬𝐮𝐬𝐫𝐢 and also the National Commissioner and Lieutenant General 𝐾ONAZI, that this appears to be a person who's been suspended, but not for the reasons that they allege. So why can't the name be mentioned?
For the same reasons that I mentioned earlier. And I'm not sure if you want me to repeat those.
No, that's fine.
Chair.
We did say that, I think that the Chair did point out that during the break you can consider your position and take legal advice and get a legal opinion if necessary. Because as you know, we in a different forum to the Madlanga Commission. You are also protected by parliamentary privilege. And it's parliamentary privilege is only lost if at the end of the day you are found to have lied or for some unlawful reason. So you are protected. So you are in a protected environment. You're not persuaded.
I'm in a protected environment. I'm trying to protect others.
Well,
for the reasons that I mentioned.
I think that person will understand that you have to make the disclosure because of parliamentary privilege that protects you, and now there is a request, strong request, from the committee that the name be disclosed.
Chair asked that I be permitted to seek legal advice on this matter and come back to the committee, but I assure the committee again that we do want to cooperate. I do want to cooperate fully.
Yeah. I think that's why the chairperson had, like with other witnesses, read out the oath and even before that explained what this committee is all about. Okay, if I'm just, I think we were going on to the statistics that you mentioned at paragraphs 71 and 72. This is all in relation to misconduct cases in the period from 2019 until March 2025. You want to discuss that briefly? 71 and 72?
Yes, so in terms of the NPA Act, there is a provision that allows for the creation of such an office to deal with issues relating to integrity. There was an integrity management unit in the NPA. But that was not in terms of the Act. We've now, in terms of the Act, set up the Office for Ethics and Accountability. And it's responsible for handling or investigating any complaints relating to improper conduct on the part of a member of the NPA, but not just reactively. It is also responsible for promoting a culture of ethics and accountability within the institution. So there is a proactive part to the functions of the OEA as well as a reactive part to it. And so we've, the Office of Ethics and Accountability And as we say, its precursor, the Integrity Management Unit, has received 58 complaints which relate to allegations of corruption from 2019 to 2025. 31 were closed as unsubstantiated, 16 referred to labor relations, and 7 were classified as representations linked to particular cases, which means there's another process to be followed and not a disciplinary process, and 4 are investigation. Of the 11 matters that were concluded, 8 employees were dismissed, 2 resigned, and 1 was found not guilty. But the Office of Ethics and Accountability is really a very important development in terms of trying to inculcate a culture of ethics and accountability in the National Prosecuting Authority, and making it clear that to prosecutors, that we serve only the people of this country. We are the people's lawyers, and we pride ourselves on being just that. And that we serve only the people of this country. We should act, as the Act says, without fear, favor, or prejudice. And this, the Constitution and the NPA Act. And this shouldn't just be a cliche. It should be demonstrated by the work that we do, that we in fact act without fear, favor, or prejudice. So this office is very important in terms of ensuring that we inculcate a culture of ethical conduct in the NPA, of the highest standards of integrity, and if these are breached, that they will be properly investigated and there will be consequences. The one thing I can assure the people of this country and this House is that when there are allegations against any prosecutor, we do not sweep it under the carpet. It's a fair process, it is properly dealt with, and there are consequences.
The issue of the suspension of this potentially corrupt prosecutor, was that referred to the Office of Ethics and Accountability? Because I see it's been referred to IDAC.
Yes, it's been referred to IDAC because I believe that there should be a criminal investigation into this matter, and we needed to get more information, because I just got, as I said, some kind of information, so we needed to look into it more carefully to ensure that at the end of the day, we can decide on what processes should follow from there. So this is the first step in what could lead to other processes as well.
But still on this theme, I'm afraid, given the seriousness of the allegation, I'm talking about this particular prosecutor, but also given, as several honorable members have pointed out, given the importance of the work that the NPA does, given that we all accept that trust in the criminal justice system across the board, NPA, the police, other law enforcement agencies, is at its lowest. Isn't a last and the more effective deterrent to name and shame errant or miscreant prosecutors, rather than going through this formal process, which one understands that must be followed, given that you've got to weigh up the rights of those accused and the accusers.
Chair, I agree.
If prosecutors should know that an allegation is made against them, it might be made public.
Chair, I agree that errant prosecutors should not be tolerated in the prosecuting authority, and there must be processes. We do not, as the NPA, make any comments about internal disciplinary processes that are ongoing. That has been a policy of the NPA. But it's not because we are protecting anybody. Processes do, as I said, when there's allegations, we make sure there's a proper process, whatever it might be, and there's consequences. Because there's absolutely no room for errant prosecutors, dishonest prosecutors, corrupt prosecutors in the NPA. And so I'm not sure whether the council is going back to, your question relates to disclosing the name of this person. But again, I'm imploring that we be given the opportunity to consult and decide on how we take it forward. And a closed session which has been proposed might be the best way forward. So I would urge that we be allowed to at least take advice on that.
Okay. Can we also perhaps just jump to the actual reason why you're here? That's in relation to allegations by General Mkhwanazi in relation to the PKTT, the Political Killings Task Team. I think you attended a first meeting, or one of the first meetings of the Interministerial Committee when it was, the Interministerial Committee was established in 2018 in May. You were appointed in 2019. Subsequently, did you attend any meeting? What was your first sort of contact with the PKTT?
Chair, if you can just refer me to the Honourable Council to the relevant paragraph, but just to say that it was in 2019, I'm not sure, but it was earlier in my tenure that there was a meeting in Durban. The meeting was attended by the Minister 𝐶𝐨𝐵 at the time. It was Commissioner Sithole who was there, and the DPP of KwaZulu-Natal was there. There were members of the PKTT. I don't know who was there from the PKTT, but it was about the Political Killings Task Team and having a dedicated capacity of prosecutors to support the work of the PKTT. And so that meeting was held in Durban, where we reached agreement in terms of how the NPA will work, the NPA in KZN will work with the PKTT. That was the one meeting that I did attend.
But you yourself, you weren't involved. I think we reference it from page 13 of the statement.
What paragraph is that, Council?
From paragraph 31. Sorry. There isn't a specific reference because of your own direct involvement is not with the PKTT at all. What you do reference is that Advocate Harrison, DPP of KZN, was involved with the PKTT, with the prosecution guided intervention that she made. You're aware of that?
Yes, that's correct, Chair. I am.
And you would have received the reports from her from time to time, certainly on an annual basis, about the work that they were doing with the PKTT.
Well, not specifically just the PKTT, but DPPs submit reports to the National Director, and we include various aspects of the operations of a DPP's work in a province. And so in the context of that, they would have been reporting, and there may or may not have been reports that related to the PKTT in that context.
And she, in relation to her own experiences, she has given evidence elsewhere, and that can be referenced.
Yes, absolutely. She's testified at the Madlanga Commission, and if necessary, she can testify before this committee.
But in the almost 7 years now that you've been in this position, is there anything that stood out for you about the work done by PKTT, whether it was a successful task team or unit, in relation to resolving political killings, in particular in the KZN province?
I can't comment on whether they were successful or not, but if, you asked me about anything that relating to the PKTT that I was involved in. There was a time early in my tenure when there were complaints by the police, I think it was particularly Minister 𝐃𝐨𝐧'𝐭, that the prosecutors were not enrolling cases were from the PKTT. And there was a bit of a problem between, in terms of how the prosecutors and the PKTT investigators were working. And there were a number of dockets that were referenced that the police were not happy about. I then got a report from the KwaZulu-Natal DPP about each of those cases, with reasons why the cases were not enrolled. But that is the one specific instance that I recall about getting a report on cases being dealt with by the PKTT from the DPP KZN. Yeah. Apart from that, there's no specific issues that came up regarding the PKTT, so I cannot say whether it was successful or not. It was something that the DPP will be able to testify about. They did work in the prosecutor-guided model that you mentioned earlier on. This model, I deal with it in my affidavit. I'm not sure in which paragraphs.
It's from paragraph 62 onwards, and you discuss it in the context of the functioning of the criminal justice value chain and the role of prosecutor-guided investigations.
That's right. So
which relates to paragraph 4.1.8 of the Honourable Committee's terms of reference in relation to inter-agency coordination among SAPS, crime intelligence, IDAC, NPA, correctional services, Metro Police, and the legal basis for directives affecting the PKTT. It commences at paragraph 56.
yes, thank you, Chair. And so, the importance of working together with our partners in law enforcement is hugely important. I mean, to state the obvious, the system can only be as strong as the weakest link. And I'll get to the prosecutor-guided model, but this is just one example of how we have tried to work very closely with the South African police in particular in utilizing this model so that prosecutors and investigators start working from a very, very early stage together in order to ensure that the evidence is something that will meet any kind of challenge in court. And so this model is not peculiar to the PKTT. It's a model that's been adopted for many years in the prosecuting authority, starting from when the specialized commercial crime units were set up. It's over 20 years ago, I think, when the police and the prosecutors co-located to deal with serious economic offenses, commercial crimes. And so we've also utilized this methodology in the PCLU, the Priority Crimes Litigation Unit, which deals with certain types of specialist crimes, for example, international crimes as well as terrorism. And the organized crime component also utilizes the same methodology. And if there's a case that is complex or high profile enough and we think there's a need for prosecutors and police to work closer together, the same methodology is adopted. And so, it really...
So just to pause there, it's not only in relation to a specialized unit or particular task team. That model would or could also be adopted in relation to a particular case, a case of some complexity.
Yes, absolutely. So, if this methodology can be adopted at, as long as the criteria are met, it's sufficiently complex.
What are the criteria?
Complexity, it depends on the gravity of the offense, the complexity in terms of corruption. There's often layering, money laundering involved. But it could also, where you require data analysis, lots of forensic work to be done, really enhances the complexity of investigations. But we could also, a matter could be high profile, but not necessarily complex. But because it is something that is a priority case, we might then say, look, there's a need for prosecutors. It could be a murder matter. That's a high-profile matter, and prosecutors and police officers need to work closely together. Then we would say, look, this is something that we should adopt this model in.
I ask that because there is some criticism. For example, why is such a model not employed here, say on the Cape Flats, where it is notoriously, it's a notorious fact that it's controlled by gangs, 27, 28s. We now see the high-profile prosecutions currently in court with Modak and Donkey Boyson and people like that. Or is it a case that they were brought to court having adopted the same model?
Absolutely, that is the response. I did say organized crime cases as well,
Yeah.
and the cases in Cape are a good example of that, where this model has been employed rather successfully, because prosecutors, investigators working very closely together in extremely difficult circumstances and dangerous circumstances to bring to book some of the most violent and dangerous organized criminals globally.
Now, you wouldn't be directly aware, but the PKTT, their reach had also been extended beyond KZN. For example, they were investigating the alleged corruption at Fort Hare and made a number of arrests there. And then also in Gauteng itself, going into and arresting Molefe and assisting the Gauteng murder and robbery unit in Gauteng. Would that have also been pursuant to adopting the same approach?
Yes, definitely. In those cases, in the Fort Hare matter, although it was a political killings task team, but their mandate clearly had expanded to include, in the Fort Hare matter, it's an economic commercial crime, commercial case. And so they were involved in the University of Fort Hare matter. And I am aware that they also were involved in Gauteng.
Has this approach enhanced and improved the success in the rate of prosecutions at the NPA, especially in relation to high-level crime, organized crime, drug syndicates, and so on?
So it certainly has, in some very, very complex matters where prosecutors and investigators work together. I don't have the figures here. I can certainly give you, I think I'm not sure if I've got the organized crime stats, etc., in terms of successful prosecutions, but I can get that.
We have your annual report.
Yes, we can certainly get those figures. They are all in there. So it's a model that works. It's an internationally recognized model, and we do have evidence that it is better. But I do think that the model itself can be improved, because even with some very complex matters, we find we're not moving as quickly as we should. And those are because of systemic problems, whether it's, lack of capacities, capabilities, whether it's corruption within our ranks. But some cases just don't seem to be moving, even though this model is adopted. So there are various challenges in the system, and the model can only be as effective as the efficiencies in a system as a whole. But we have found that where we do employ this model, it does work better in terms of the results.
Because, as you well know, better than anyone actually, that there is a lot of frustration amongst members of the public, even the honorable members in this House, that that the high-level criminals are not being prosecuted successfully and not being seen to get into what is called orange overalls. Or you can also in that context discuss several of the referrals that were made from the Zondo Commission to the NPA and the prosecution of those individuals.
So I think firstly, Council, if before I answer your specific question, just in terms of coordination as a whole, the PGI model is just one, that's a prosecutor guided, is one model. But I think a really good example of how we did well as a country was coming out of the FATF grey listing. And that was really an example of how, when we as government come together with a common objective, and we put the necessary skills, resources, capabilities, and energy into making sure we get over the line, we can do it. And the FATF collaboration is an excellent example of, because you have, it's not just law enforcement, it's government, it's agencies across government. So we're looking at Treasury, we're looking at the Reserve Bank, we're looking at state security, the police, SARS, the NPA, and all of these entities, the Department of Justice because of mutual legal assistance. So a whole of government approach in 2 years for us to get over the line, to get off the grey list, was a monumental effort by various entities in government. But again, it's a really good example that we can, when we get together with a common objective, deal with something effectively. And so I hope that we can take lessons from the FATF process to make sure that we're able to deal with some other types of priorities and matters that need attention in our country. Dealing with the high-profile cases not coming to court, I really want to make the point that a prosecution is only as successful, and I'll get to Zondo because, the Zondo Commission recommendations, because in the NPA, the IDAC has an investigative capacity to investigate very specific matters that are in the Act, specified in the Act, its mandate. But with regard to dealing with organized criminals, the kingpins that are not or rarely brought to court, I think the Western Cape organized crime is a good example. But the reality is that we are not winning the fight against organized crime in this country. And it all starts with good intelligence. The only way of getting to organized criminals is to ensure that we have solid, good intelligence that investigations can be built around. And the other way is you have to follow the money. We have to make sure that we have capabilities, capacities in government to be able to do effective, quick financial investigations, because people at the upper echelons of organized criminality don't get their hands dirty. So, but they certainly don't stay far away from the money. So whether we're dealing with all kinds of organized criminality, a range of them, whether it's drugs, whether you're dealing with wildlife crime, whether we are dealing with gangsterism, fuel theft from pipelines, illegal mining, environmental crimes, all of this requires us to have capacities and capabilities to deal with more effectively with investigating money trails. But it starts. But
can you explain the relative success of the SIU, the Special Investigation Unit, even your own asset forfeiture unit, because they follow the money. And they go to the special tribunal, they go to court, and they freeze huge amounts of assets, and subsequently they get forfeiture orders, and billions is paid into the state account. But the people who are involved in the proceeds of this illicit amounts of money, they still are free, they still walk free, they are not being prosecuted. So perhaps this is an opportunity to just explain the differences, the standards of proof, the kind of evidence that you need to successfully criminally prosecute these people.
So the work of the SIU is, of course, to deal with civil recoveries primarily. And the standard of proof in terms of the SIU Act, which I don't have in front of me, but it is on a balance of probabilities. It is not a criminal standard. And in terms of the SIU Act, where there is evidence, and I stand to be corrected because I don't have the Act in front of me, where there is evidence that points towards criminality, then the matter must be referred to the National Prosecuting Authority. This in itself, and I would ask honourable members, when you are looking at amendments to the SIU Act, that an amendment be effected to the effect that when the SIU finds evidence that points to criminality, that they refer the matter to an investigative agency, not to the NPA, because but for a very small group of, class of crimes that could go to the IDAC, the majority of these matters, when we get them, we have to send them to the DPCI for criminal investigations, because the standard in criminal investigations, and I deal with it somewhere in my affidavit, is a reasonable prospect of a successful prosecution. And that means we have to ensure that that is only when that standard is met are we able to then decide to prosecute. And we have got figures on, we in fact have reported to Parliament, many times appeared together with the SIU and the DPCI to deal with all of the referrals from the SIU, what happens to those matters, those that are prosecuted, those that aren't. And so there's a huge difference between a civil standard of proof and a criminal standard of proof. And the same applies for the Zondo Commission. The Zondo Commission did not give the law enforcement a blueprint for prosecutions. They actually, gave us a lot of information, leads, evidence, but we still needed to investigate to ensure that we met the standard of proof required for criminal investigations. So I have somewhere, Chair, if you'll just give me a few moments to just access these figures that will actually give the committee a better understanding of what the position is regarding the Zondo Commission recommendations. Advocate Johnson did allude to this, but if I'm allowed to just look at the work of the IDAC again in terms of its numbers, and I'm struggling to find it in my, but if the committee will allow me, I'll look at the actual figures, but we are looking at over 300 entities and accused persons that are already in court as a result of the work of the IDAC. I also want to emphasize that, yes, of course, the frustration that you talk about in terms of people not yet being in orange overalls is something that, as the National Director, I feel as well, because I would have certainly, as I said earlier on, hoped that some of these cases moved quicker, not just through the investigation phase, but also after they are enrolled. With regard to the investigation of these matters and why they've taken this long, many of them, although there are over 300 matters that are enrolled or accused entities and persons in court. The IDAC was made permanent in August last year. And prior to that, the capacitation of the IDAC was dependent on secondment model, and that is you have other entities, government agencies that actually second resources to the IDAC. It was extremely difficult because when you have other agencies that are also struggling with capacitation challenges, you don't expect that they are...
Then to do what if you can't intervene when there is a need to intervene? Maybe let me illustrate through a practical example. This section says you can direct the DPP to give you a report in any case. Let's say you request for a report for a particular case, and you realize that actually there is no prima facie evidence here to prosecute. Now you say the Act does not give you powers to direct the DPP to either prosecute or not prosecute. So in the event where you request for a report for a particular case, and you realize in that case that actually there is no case here, so does that mean your hands are tied in that regard? You can't advise the DPP to say, let's take this case out because there's no prima facie. Is that what you mean?
Thank you, Chair. That's an important question. So if there's a report received from a DPP, and generally the reports of the DPPs don't go into detail of all the evidence that's in a docket. But if the scenario that's sketched out by the Honourable Member does play out, that there is a report and that it appears from there that there's no prima facie evidence, that is a serious non-compliance of the prosecution policy. And in those circumstances, the NDPP would be able to say, I'm going to review this matter. I want all the evidence, I want the entire docket to be sent to me or a national director, and then the matter is reviewed and a different decision that decision can be overturned.
Now, upon reviewing the matter, and you realize that actually there is no prima facie, after we have engaged in your investigation, then you come to a realization that there is no prima facie, then you can advise the DPP not to continue with prosecution, right?
Honourable Chair, it's not an advice to the DPP, but it will be the National Director overturning the DPP's decision.
Then it means you can have a decision on whether the DPP can prosecute or not.
Precisely.
Exactly.
So if the matter is, it's not a matter of advice, the National Director takes a decision to overturn the decision of a DPP, and then the charges must be withdrawn.
And you call that an oversight mechanism. How do you call it?
It's a review process in terms of the Act.
Okay, no, thank you.
Yes, sir.
So just in summary, following that question by Honourable Nomvalo, you do not and cannot interfere in any original decision taken by a prosecutor to prosecute a case, save where a matter is referred to you on review.
That's correct. And the National Director can, if the National Director is of the view that prosecution policy has not been complied with, then you can intervene. But generally, it's on a review process. Otherwise, it is legally incorrect to direct that a DPP prosecutes or not prosecutes a matter.
Well, isn't that perhaps a thin end of a wedge, that under the guise of saying that a prosecutor hasn't followed prosecutorial directives, which are operational, isn't it, in terms of your statement?
Directives are more operational.
They're operational, and so a particular step, for example, hasn't been followed. But how would you know, or who would bring that to your attention, which may result in you intervening, if it's not on review?
That's a valid question. It could be brought to a National Director's attention by any number of persons. It could be a complainant, it could be an accused person, it could be a prosecutor. But when that is brought to the attention of the National Director, you can intervene if it's a question of non-compliance with the policy or the directives. But generally, these matters are brought by way of a formal representation for a review of the matter by the National Director.
Thank you. Chair, if we can adjourn on that point.
Okay. Thank you so much. SC, thank you so much, Advocate Batohi. We'll come back at 14 hours.